of cases, that is maintenance for destitute wife and children and also parents. You please remember that there is a lacuna in the present CRPC under 125 with regard to the place of filing of petition by parents seeking maintenance against their children. However, that lacuna is now answered in the new CRPC, and now parents can file a petition seeking maintenance at the place where they are residing. That is one aspect you please remember. And as far as parents are concerned, there are, apart from 125 CRPC, there is another enactment with regard to Senior Citizens Protection Act, in which proceedings take place before RDO. This act gives power to the RDO, who is designated as the officer to conduct proceedings, to cancel a gift deed or a settlement deed executed by both parents or one of the parents in favor of their children, with a condition that children should look after them. So if the children fail to look after these parents, then the RDO has got power to cancel this gift deed. This is one area of protection of rights of senior citizens. And the act is a very simple enactment, and a speedy remedy can be availed on behalf of parents. If you come across a case where parents have been neglected to be maintained by their children, and when children take advantage of the gift deed executed in their favor. Therefore, please purchase a bare act of this enactment and have it. There is also case law. The recent case law is that the gift deed or settlement deed should contain a clause that children have undertaken to maintain their parents. And when there is violation of this clause, the gift deed can be set aside. This is a speedier remedy than seeking cancellation of a document under the specific relief act by way of filing of a suit. This is one aspect on which we should have thorough knowledge. 125 PC as amended in the new code, and this act, they come to the rescue of old aged parents and they are neglected by their children, and they are unable to maintain themselves. So this is one aspect. The second aspect is maintenance is provided for in several enactments. If there is a marital dispute pending under Hindu Marriage Act, then interim maintenance can be sought, and the court may order the husband to pay costs of litigation to the wife, and interim maintenance may be awarded for children also. And ultimately, an order of permanent alimony can also be passed after the marital dispute is decided. Therefore, this is one enactment where interim maintenance can be sought during the pendency of the proceedings under Hindu Marriage Act. Second enactment is a general enactment and a speedier remedy under 125 CRPC. Previously, there was a limitation on the amount of maintenance that can be awarded to the wife and children. But now that limitation is removed, not now, more than 10 years ago. Therefore, 125 CRPC is a provision which is hailed as a social welfare legislation, which comes to the rescue of destitute wife and children. And they can seek maintenance by way of filing a petition under 125 CRPC. Please remember that strict proof of marriage is not necessary in these proceedings, and even if the wife is unable to produce proof of marriage, then if there is cohabitation for a considerable period of time, the law favors a legal relationship. One practical aspect of filing a petition under 125 CRPC is if petitioners reside in a town or city where family court is established, then the family court will have jurisdiction to decide cases under 125 CRPC. If you file this petition before the family court, then the next appeal would be the forum of next appeal may not be in the reach of the wife and children. Therefore, when you are filing a petition for maintenance in a city where Family Courts Act is established, better to file it under Domestic Violence Act, which is also a speedy remedy. And there are several other reliefs which can be sought under the Domestic Violence Act. I hope you are aware of the other monetary remedy compensations that can be granted under the Domestic Violence Act. If the woman is harassed, initially the act said that only male members can be respondents within a family where there is domestic relationship between the petitioner and respondents, but the High Court of AP held that respondent may be a woman also. Therefore, under the Domestic Violence Act, not only maintenance, but other reliefs like compensation for harassment, if the Husband goes to the place where the woman is working and creates nuisance there. All these aspects are dealt with under section. All these types of monetary compensations can be awarded under section 20 of the Domestic Violence Act. The procedure is very flexible. The magistrate can decide the issue of maintenance and other reliefs by formulating necessary procedure. The proof of domestic violence is, as per the act, this phrase, prima facie satisfaction of the magistrate that domestic violence has occurred. Domestic violence may be economic exploitation, economically abusing the wife. Sometimes it may be sister also, it may be mother also, it may be emotional, it may be physical abuse, and the magistrate, after hearing both parties, after receiving an application under section 12 of the Domestic Violence Act, will decide the issue. And under this act also interim maintenance can be granted pending the proceedings. One important facility that is created under this act is the institution of protection officer. Protection officer is supposed to give solace to the victims of domestic violence, if necessary provide them shelter if the woman is driven out, give legal aid for filing the petition, process the filing of the petition, and help the petitioners to conduct the litigation. The protection officer is to work under the control of magistrate for the purpose of collecting certain information regarding the assets and liabilities of the respondent. This is a rule which can be found, I think, Rule 10 under the rules framed under Domestic Violence Act. And this rule can be availed by filing an IA along with the main petition, seeking the magistrate to order the protection officer to collect these details so that a reasonable amount of maintenance can be granted or other monetary orders can be granted. There are instances where the respondent is working in a private company and there is no material available with the petitioners regarding the assets and liabilities of the respondent. While handling appeals also, I have directed the protection officer to send the details, even though the respondent is working outside the jurisdiction of the court. And I got results and I got information from the employer about the quantum of monthly income derived by the respondent. So this is a speedy remedy. However, a word of caution and a word of prudence to all of you. Even if the petitioners want several people to be added as respondents, please verify whether these proposed respondents had anything to do with the marital dispute, whether they had really caused any domestic violence, whether they ever visited the petitioners after the marriage. Unnecessarily adding all these respondents may not be of any avail. They will go to High Court, get the matter stayed, or bring some order, and ultimately the matter gets delayed. Therefore, add only those respondents who have really committed domestic violence as against the petitioner. Adding all relatives may not be of much avail when you file a petition under Domestic Violence Act. Another thing is, the petition can be filed by the father or a relative of the petitioner also on her behalf, even while she is staying in the house of her husband. An order of protection can be sought against the husband and anybody else who is causing emotional, economic, or physical abuse against the petitioner. The essential difference between the proceedings under 125 CRPC and the proceedings under Domestic Violence Act are that the petitioner can reside with her husband, claim to be in the shared household, and seek a protection order against the husband and others who are actually causing domestic violence. This petition may be initiated, as I said, by the father of the petitioner also, depending on the information given by the petitioner herself. Therefore, it is not necessary that the petitioner should leave the shared household of her husband and come out and file a petition. In fact, the Act provides for a distress call to the protection officer to protect the petitioner, and the protection officer is supposed to and authorized to take the help of the local police and go to the place where the petitioner is staying along the petitioner gives a call to the protection officer and the protection officer informs the police. They are under the impression that they have to register a case of 498 IPC, in which case it will be very difficult for the woman to live there. But the Act does not contemplate such a course of action by the police. The call is intended to protect the uh, petitioner against acts of domestic violence. It is a symbolic act where the police go, they say that they came to give protection to the petitioner, and it is as though the apparatus of the state administration, is coming to the rescue of the woman. Therefore, please go through the Act. It's a brief enactment containing some 32 sections. And the rules, there are formats: domestic incident report to be sent by the protection officer. There are instances where cases are settled when the protection officer issues notice to the respondent, and the protection officer and the legal service authority work in tandem, cooperate with each other, and try to settle the issue even before it reaches the court. Therefore, my sincere request to advocates is that domestic violence, if utilized with clarity and also diligence, then it will give good results to restitute wife and children. As far as the proceedings are concerned, I told you that the magistrate is supposed to dispose of the matter within 3 months, or even if it is just more than that, you can get all the reliefs that a wife needs to be given in case where domestic violence has really occurred. And there may be conciliation also regarding the disputes between wife and husband before the protection officer or before the district legal service authority if the protection officer
రాయల్ సర్టిఫికెట్ ఉంటారా
refers the matter to the legal service authority for conciliation. So I request you to be very much conversant with the act and the rules thereon. And I just want any one of you to post a message as to the latest decision on this aspect rendered by the Supreme Court. That is maintenance. Can anybody post the judgment, which is very much relevant and which should be known to all advocates conducting cases seeking maintenance? So I'll give you some time for you to post the cause title of the judgment and I'll proceed. Now we have considered three enactments: protection of senior citizens, 125 CRPC, and domestic violence. Now Hindu Adoptions and Maintenance Act. It is an enactment in which a charge can be sought against the properties of the husband for the payment of maintenance. And I broached this aspect when I spoke on two occasions during early hours, that is 5 a.m. to 6:30 a.m. more than 7 or 8 months ago. An unmarried daughter can seek the cost of her marriage from her father. This claim is not specifically mentioned as a separate claim in the Act. It is part of the definition of maintenance under the Hindu Adoptions and Maintenance Act. There is no other enactment under which a minor daughter can seek the cost of marriage. Minor daughter, or even for that matter, an unmarried daughter can seek the cost of her marriage from her father. Therefore, this is a provision which can be utilized sometimes when the father is having sufficient properties and is not interested in performing the marriage of his daughter or providing any funds for that purpose. And there can be a suit on the basis of a suit seeking that relief, and of course suit for maintenance of wife and children under this act. As I told you, the respondent, if the defendant is having properties, immovable properties, the payment of maintenance will be a charge on those properties, and the charge will continue even if the property is sold. The sale will be subject to the charge in favor of the petitioners. This is another enactment which relates to a claim for maintenance and marriage expenses of an unmarried daughter. And then there is Muslim Women's Protection Act. But now Domestic Violence Act has come. It doesn't make any difference whether the petitioners are Hindus or Muslims or any other persons belong to other religious sects. Therefore, Domestic Violence Act can be utilized. And even a divorced wife can claim maintenance, either under 125 CRPC or other enactments. The word used in Domestic Violence Act is who is or has been or was under domestic relationship with the respondent. So now anybody has posted the judgment with regard to maintenance, which is of great importance while conducting cases seeking maintenance.
Yes, sir. Rajneesh versus Neha, someone posted.
Yes, Rajneesh versus Neha is the judgment of the Supreme Court, which should be a copy of the judgment should be on the table of the advocate for ready reference. It gives several directions as to what should happen when maintenance is sought under different enactments. For example, 125 CRPC, the section itself says that the maintenance will be considered as and when the parties again seek maintenance in a civil suit. The parties will have to file affidavits relating to their assets and liabilities. And I request everybody to go through the entire judgment and follow the directions given by the Supreme Court while filing cases for maintenance before courts. This is very, very important. I think the judgment was rendered somewhere in November 21 by the Supreme Court and reported immediately. Or even otherwise, if you just go to the Google and say Rajneesh versus Neha, you will get the entire judgment. You can take a printout and keep a copy on your table. So as I told you, judgment law is sometimes so important that we cannot ignore it. And if it is on the procedural side, we are bound to follow the same. After conducting cases under so many enactments, my opinion is that Domestic Violence Act has better uh, application if really domestic violence occurs, and it is also a speedy remedy. As I told you, there need not be proof of domestic violence beyond reasonable doubt, as in criminal cases, or proof of facts, as in civil matters. But the word used in the section is, and the act is, prima facie satisfaction of the marriage, of the commission of domestic violence. Therefore, please note all these aspects, have an idea of the remedies provided under the Domestic Violence Act. As and when a protection order is passed, it should be communicated to the SHO of the local police station within whose jurisdiction the petitioners reside. It is only when the protection order is infringed that a criminal case can be filed along with the affidavit of the petitioner. Initially, when the Act came into force in the year 2006, the Act was enacted in 2005, but came into force in 2006. There was registration of criminal cases under the Act, but that is not the procedure. Now, of course, everybody is clear about it. But if you think that the protection order issued by the court is not honored by the respondent or it is violated by him, then a prosecution under the Act can be launched against the respondent. So the Act contains some sort of solace by the protection officer at the stage of filing the petition. The petitioner staying in the shared household and still filing a petition for protection. A distress call to the protection officer seeking protection. In fact, I request all advocates to bear this in mind, because if any of you are having interest in participating in legal literacy camps, this should be known to all women, married women, or even ordinary women who come under the Domestic Violence Act. This will protect a possible offense of 304 BIPC or suicide of a woman unable to bear the harassment. Therefore, if a father comes to you stating that I have given my daughter in marriage, she is being subjected to economic abuse, I am asked to pay additional dowry, or she is being physically assaulted, then without any legal proceeding, you can advise the person to go to the protection officer who is authorized to give immediate protection to the woman, even when she is with her husband. So this is the beneficial provision provided under the Domestic Violence Act, and I request all advocates to bear it in mind. Even without filing a petition before the court, there can be protection to the victim, and there may be a scope for rectification of the conduct of the respondent, because the state is coming to the rescue of the victims. That is the intention behind this act. Unfortunately, we do not have full-time protection officers. Only an officer in charge of woman welfare at this district level is also designated as protection officer under the act. RDOs are also designated as protection officers under the act. Therefore, please be aware of the rules, the notifications, and the interim measures available under the act. In marital disputes, the role of the advocate is to give immediate solace to the victim, including children, and also give a chance for the marriage to be continued instead of taking hasty steps like filing a case under 498A IPC. There can be a pre-litigation case before the District Legal Service Authority without filing any of these petitions. And there have been instances where cases have been solved, not because of the ability of the Lok Adalat to convince these spouses, but spouses themselves reconcile. I had the experience of a husband and wife married about 1 year, married for about 1 year, no children. I conducted conciliation. They were determined to live apart. The issue was not settled because the quantum of maintenance was not agreed to by the husband. I think there was a gap of some 50,000 or 1 lakh in the amount offered by him. They said they would come again. Conciliation failed for the present, but 3 or 4 months later they came and they said they are living together. Therefore, in the initial stages of disputes between the spouses, we have to give a chance for reconciliation. There was also a case where husband belonged to Muslim community, took back his wife, even though he said he could prove adultery on the part of his wife. When there was a conciliation prior to the registration of 498 IPC, as per the judgment of Supreme Court, 2017 and 18, before the judgment was revoked by the Supreme Court, when during the conciliation, when the woman was asked, particularly illiterates, what is the purpose for which you went to criminal court? They said they didn't know. So 498 is the last resort as far as marital disputes are concerned. When once 498 IPC is filed, all doors for reconciliation close in most of the cases. Even if the husband agrees to live with his wife, the other persons named in the FIR will say, no, 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 if you live again, if you live together, again we'll be at the risk of facing a criminal case. Therefore, the role of the advocate is very sensitive in marital disputes. And I request advocates to utilize the service of the District Legal Service Authority and the Mandal Legal Service Committees at the stage of pre-litigation to bring about a settlement between the spouses. Now, this is about maintenance, and as far as 125 CRPC is concerned, it contains provisions to implement the order. The respondent may even be sent to prison if he doesn't pay the maintenance. As I told you, under the Hindu Adoption Settlements Act, charge can be created. What is the quantum of maintenance that can be awarded by the court is an aspect which depends on the financial status of both parties. Apart from the judgment in Rajneesh versus Neha, where maintenance is sought under more than one enactment, the trend of judgments of Supreme Court is that it should be that the quantum should be in consonance. That means in line with or proportionate to the status of the wife, and also taking into consideration the income of the respondent. There have been cases in which 25,000 per month was given as interim maintenance considering the income of the husband. In proceedings under 125 CRPC, the judgment of the AP High Court rendered some more than 30 years ago is that one-third can be granted, one-third of the income of the respondent can be granted towards maintenance. So regarding quantum of maintenance also, you have to cite the decisions depending on the information produced before the court about the status of the respondent, status of the wife, income of the respondent. Now that affidavits are provided as per the judgment in Rajneesh versus Neha, then the issue is simplified. So this is about proceedings for maintenance, and I am quite sure that this is one class of litigation which is increasing and which requires a service motive on the part of the advocate. And with regard to the mode of payment of interim maintenance, as and when ordered by the court and when the respondent pays, the petitioner can provide bank account number and the amount can be directed to be deposited into that account. To avoid depositing of the amount in the court, filing a check petition and then withdrawing the amount. Family courts are allowing this, and even in magistrate courts you can adopt this method. I think I have covered most of the issues arising in cases for maintenance, and there are very few defenses available to the husband. Say under 125, intentionally living, voluntarily living away from the husband, or living in adultery, but in more than 90% of the cases, maintenance will be granted as per the parameters relating to the status of parties. A second wife who is not legally wedded to the husband is not entitled to maintenance. Under the Domestic Violence Act, any sort of live-in relationship is also covered. Any relationship in the nature of marriage. But again, there is case law. If the woman is married and is still living with somebody else in a live-in relationship, she may not be entitled to maintenance. So these are some of the aspects relating to maintenance. And a petition under Domestic Violence Act can be filed in any proceeding pending between the parties. Suppose a divorce proceeding is there, a petition under Domestic Violence Act can be filed in the same proceedings, claiming other monetary reliefs which I have mentioned are provided for under the Act. Therefore, we need not go to the magistrate court for filing the petition seeking certain reliefs. Today, what's the time, madam? Sridevi garu,
Yes, sir. Yes, sir.
what's the time?
7:50, sir.
7:50. Okay. So, any doubts regarding the
Any
filing of petitions under various enactments? If anybody is having, any advocate is having good number of cases relating to marital disputes, there is a journal which reports these cases. I think it is a journal with the name of matrimonial cases. You can subscribe to that journal and have the benefit of latest cases. Sometimes some aspects are covered by judgments of Bombay High Court and Karnataka High Court. I have seen this journal, I have referred to this journal and noted down case law. And I found that in some peculiar situations, the judgments of these other high courts are also important for conducting the cases.
What is the journal name, sir?
I think it is matrimonial cases.
Okay.
Some other word is there in the beginning, but you can browse for it and you can find it easily.
Yes,
It
sir.
is there in the Telangana Judicial Academy. I have seen it. Unfortunately, this journal is not supplied to all family courts or magistrate courts, but it has got its own value for practicing advocates. It will also contain judgments relating to 304 BPC, 306 IPC, and all. Yes, sir. Again, all the precautions which I have stated with regard to taking instructions from the parties, they apply. You have to take proper instructions from the party before conducting these cases. And one more suggestion, if because I don't want to clearly advise you on this, one more suggestion which I have given to senior advocates also and which they are following, please ask the parties to write down what had happened if they are literate. Because in disputes between spouses, there will be so much of information. Ultimately, you may not be accused of not putting forth a particular incident between them. Therefore, how the marriage was fixed, was it an arranged marriage or was it a love marriage? What is the nature of the marriage? Is it a registered marriage or a marriage as per personal law? Where the marriage occurred, where there is marriage certificate, how disputes arose, if there is payment of any amount in the nature of dowry, what is the mode of payment? Was any property sold for the sake of payment of dowry? Was any property mortgaged? Was any loan taken by the father for payment of dowry? and what exactly are the incidents of
మీరు మ్యూట్ లో వెళ్ళారు సార్. హలో సార్. Someone find out that what is family law journal. You please let us know. So all will get the help of it. I will also search. ఏదైనా ఫోన్ వచ్చి ఉండాలి.
Yes, am I audible now?
Yes sir, yes sir. Now
Yes, yes. So it is in the interest of advocate also not to be unnecessarily commented by the parties that you have not incorporated so and so incident in the petition, you have not edited it in the chief examination, or you have not asked in the cross examination. Please take the details of the case in writing by the party in their own handwriting if they are literate. If they are illiterate, and if you think that they are likely to cause embarrassment at a subsequent stage, tell them that you are recording what they are saying and record it in your cell phone or any other mode. Nothing wrong. It may be a confidential communication, but all the same, it will come to your rescue when you are preparing the case, either for filing before the court or for cross-examination or chief examination. So this is my sincere suggestion. I do hope that we will follow it. So this is a big topic. This is a big topic. And Sridev Garu, please collect all the doubts of our participants
yes,
in
sir.
writing, consolidate them and we will answer, because this is one area where you should be very thorough while conducting cases, with the provisions as well as with the
Procedure.
procedure.
Yes sir.
Okay. So today also I am leaving. Don't think that I am taking hardly 1 hour, but that is what
Yes sir.
that
We
is
can
my
understand.
problem, because I'm outside Vizag. Tomorrow I'll be reaching Vizag, and day after tomorrow I'll take up another topic of practical importance to it.
Yes sir, yes sir.
Oh, thank you.